Could the government, without a judge's prior approval, tap the telephone lines of American citizens, open their private mail, and infiltrate their political gatherings, all in the name of national security? For decades, this question wasn't hypothetical. It was the chilling reality of intelligence operations within the United States. A stark counterpoint to the nation's foundational promises of liberty and freedom from unwarranted intrusion. The revelation of these clandestine activities would eventually shatter public trust, exposing a vast unchecked apparatus of domestic surveillance that operated in the shadows, far from the scrutiny of the courts or the public eye. It was an era when the line between protecting the nation and stifling dissent blurred almost to the point of disappearing, leaving a profound scar on the American psyche and raising an urgent fundamental question about the very nature of privacy in a democratic society. The mid-20th century cast a long, cold shadow over the American landscape. The palpable fear of communism, both abroad and within the nation's borders, became the crucible in which new doctrines of national security were forged. The world was gripped by an ideological struggle, a global chess match between East and West, and the perceived existential threat permeated every facet of American life. Loyalty oaths became commonplace, a McCarthyite fervor swept through institutions, and the notion that foreign subversion lurked in every corner gained pervasive traction. This climate of suspicion provided fertile ground for the expansion of federal agencies' domestic powers, particularly the Federal Bureau of Investigation, FBI, under J. Edgar Hoover. What began as a mission to counter espionage and sabotage during wartime slowly, almost imperceptibly, metastasized into a sprawling domestic intelligence network with few internal checks and even fewer external restraints. The legal framework was, at best, ambiguous, often relying on broad interpretations of executive authority and an unspoken deference to the supposed exigencies of national defense. Within this environment, the FBI, an agency originally tasked with investigating federal crimes, transformed into a powerful domestic intelligence arm, taking on a role far beyond its initial mandate. Its methods were often crude but effective, relying heavily on physical surveillance, informants, and the burgeoning technology of wiretapping. The process was astonishingly straightforward and largely unregulated. An agent would identify a target, often based on vague suspicions of communist sympathies, civil rights activism, or anti-war sentiment, and then, with internal approval, sometimes from Hoover himself, proceed to implement surveillance. There was no independent judicial review, no requirement to demonstrate probable cause to an impartial judge. The decision to invade a citizen's privacy rested almost entirely within the executive branch. This operational autonomy, born of perceived necessity during a time of intense global conflict, created a dangerous precedent, allowing the intelligence community to define the boundaries of its own power, often to the detriment of constitutional safeguards. The chilling question lingered in the air. If the government deemed you a threat, who would stand between you and the full force of its surveillance capabilities? One of the most infamous manifestations of this unchecked power was the FBI's COINTELPRO, an acronym for Counterintelligence Program. Launched in the 1950s, it was initially aimed at disrupting the Communist Party USA, but quickly expanded to target a vast array of domestic groups deemed subversive. This included the Socialist Workers' Party, the Ku Klux Klan, and perhaps most controversially, the Civil Rights Movement and the anti-Vietnam War movement. The disruption tactics were not limited to simple information gathering. They encompassed a wide spectrum of covert operations designed to discredit, destabilize, and neutralize these groups and their leaders. Agents forged documents, planted false stories in the media, sent anonymous letters designed to create dissension, arranged for false arrests, and even instigated violence between rival factions. The goal was not merely to observe, but to actively interfere with the lawful exercise of political speech and association, making a mockery of fundamental First Amendment rights. The technical details of wiretaps were equally disquieting. Agents would physically access telephone lines, often through agreements with local telephone companies who, under pressure from the FBI, would comply without requiring court orders. Microphones, often referred to as bugs, were surreptitiously installed in homes, offices, and hotel rooms. The mail was intercepted and opened, a practice known as mail covers, often performed without any legal basis, simply by having post office employees flag certain envelopes for inspection or copying. These were not the actions of a rogue agent or a single misguided operation, but a systemic pattern of behavior deeply embedded within the institutional culture of the FBI, justified by the omnipresent specter of internal enemies. How many conversations, how many private thoughts, how many innocent lives were swept into this vast dragnet without a single accusation of criminal wrongdoing ever being made? Consider the experience of a young civil rights organizer in the Deep South during the 1960s. Let us call her Alice. She works tirelessly, organizing voter registration drives, speaking at local churches, her voice ringing with conviction against injustice. One sweltering summer evening, after a long day of canvassing, she returns to her small rented room. She picks up the receiver of her rotary phone to call a colleague about a strategy meeting. As she dials, she hears a faint, almost imperceptible click, a slight echo on the line that wasn't there before. A fleeting shiver runs down her spine. Later that week, she notices a small tear in the flap of a letter she received from her sister, a tear inconsistent with standard postal handling. A book she left on her bedside table seems to have been moved ever so slightly from its original position. Perhaps it is just her imagination, the exhaustion playing tricks, or the constant low thrum of fear that permeates the activist community. But the unease persists. She begins to choose her words more carefully on the phone, to avoid discussing sensitive topics in her home, to write critical notes on scraps of paper that she then immediately burns. The simple act of living, of organizing, of speaking truth to power is now tinged with a corrosive paranoia. The knowledge, or even just the suspicion, that unseen eyes and ears are constantly monitoring her every move stifles her spontaneity, erodes her trust in the very air she breathes. The government, ostensibly her protector, has become an unseen shadow, a silent auditor of her most private moments, not because she committed a crime, but because her ideals were perceived as inconvenient or threatening to the existing order. This subtle, insidious pressure was a weapon far more potent than direct confrontation, designed to isolate, intimidate, and ultimately, to silence. The cumulative effect of these revelations was devastating. When details of COINTELPRO and similar programs came to light in the 1970s, largely through courageous leaks and subsequent congressional investigations, the public outcry was immense. The targeting of figures like Martin Luther King Jr., subjected to relentless surveillance, character assassination attempts, and even an anonymous letter urging him to commit suicide, exposed the sheer depravity of the operations. Public trust in government institutions, already reeling from the Vietnam War and the Watergate scandal, plummeted to new lows. The fundamental promise of American democracy, that its citizens are free to speak, assemble, hold dissenting views without fear of government reprisal, seemed to have been profoundly violated. The constitutional right to privacy, a concept deeply ingrained in American legal tradition, even if not explicitly enumerated, had been trampled underfoot. Scholars and civil liberties advocates argued vehemently that these practices were not just abuses of power, but a betrayal of democratic principles. Yet, some within the intelligence community and government circles at the time offered a different perspective, arguing that such extreme measures, however unpalatable, were unfortunately necessary. They contended that the threats posed by communist infiltration and radical domestic groups were real and that conventional law enforcement tools were insufficient to counter sophisticated subversion. The argument often centered on the idea that the nation was in a state of undeclared war, and in such circumstances, extraordinary measures were justified to protect national security. One version of this argument suggested that while specific tactics might have gone too far, the underlying impulse to gather intelligence on perceived enemies of the state was legitimate. Another interpretation posited that the abuses were a consequence of a lack of clear legal guidance, rather than an inherent desire to violate rights. Without a clear legislative framework to delineate what was permissible and what was not, agencies like the FBI operated in a legal gray zone, often defining their own rules of engagement. This perspective, while not excusing the abuses, sought to frame them as an unfortunate consequence of an ill-defined mandate in a dangerous world, rather than malicious intent. However, for the millions of Americans whose privacy was breached, whose dissent was monitored, and whose lives were subtly, or sometimes overtly, disrupted, the motivations mattered little compared to the chilling reality of government overreach. The question remained: could a nation dedicated to liberty find a way to protect itself from genuine threats without sacrificing the very freedoms it sought to defend? How could the necessary work of intelligence gathering be conducted without devolving into the kind of unchecked domestic spying that had so thoroughly eroded public trust? The answer, many believed, lay in a radical new approach, one that would introduce a layer of judicial oversight into the secretive world of intelligence, a concept previously almost unimaginable. The clamor for accountability, amplified by the seismic shockwaves of Watergate and the damning revelations of the Church Committee hearings, propelled the United States into a period of profound introspection regarding the immense power wielded by its intelligence agencies. The committee, led by Senator Frank Church, laid bare a decades-long pattern of surveillance abuses, assassinations plots, and covert operations both at home and abroad, conducted with astonishing impunity. Its findings, published in the mid-1970s, painted a grim picture. Agencies sworn to protect the American people had instead spied on them, undermined their political movements, and even attempted to manipulate their leaders. The sheer scope and audacity of these programs demanded not just reform, but a fundamental restructuring of how intelligence operations were authorized and overseen. The central paradox was stark. How could a free society equip its government to defend against elusive, often hidden threats without granting it the tools to become a threat to its own citizens' liberties? The ensuing debate was fierce, pitting national security imperatives against deeply held constitutional principles, ultimately seeking to establish a delicate balance where none had truly existed before. Out of this tumultuous period of public debate and legislative wrestling emerged the Foreign Intelligence Surveillance Act, FISA, of 1978. It was a landmark piece of legislation, a direct response to the abuses documented by the Church Committee, and represented a revolutionary attempt to bring judicial oversight to the secretive realm of foreign intelligence gathering. For the first time, intelligence agencies seeking to conduct electronic surveillance or physical searches for foreign intelligence purposes within the United States would be required to obtain a warrant from a newly created specialized court. This was a monumental shift. No longer could the executive branch unilaterally decide who would be monitored. Now, an independent judicial body would serve as a check on its power. The very existence of this secret court, as it would inevitably come to be known, was a testament to the nation's determination to rebuild trust and prevent a return to the unchecked surveillance of the past. It was an ambitious attempt to codify the delicate balance between the need for national security and the inviolable right to privacy. A balance that had, for too long, tipped precariously towards the former. The core of FISA's innovative structure was the establishment of the Foreign Intelligence Surveillance Court, FISC. This court, initially composed of 7 federal district court judges selected by the Chief Justice of the United States and later expanded to 11, would sit in a secure, undisclosed location, primarily within the Robert F. Kennedy Department of Justice building in Washington, D.C. The proceedings were and remain entirely ex parte, meaning only one side, the government, is present and conducted in secret. An application for a FISA warrant would be submitted by the Department of Justice on behalf of an intelligence agency, primarily the FBI, and would detail the target, the type of surveillance requested, and the probable cause for believing that the target was a foreign power or an agent of a foreign power. The standard for approval required a finding that there was probable cause to believe that the target was indeed a foreign power or an agent thereof, and that the purpose of the surveillance was to obtain foreign intelligence information. This was a crucial distinction from traditional criminal warrants, which require probable cause of a crime. FISA warrants were about gathering intelligence to protect national security, not primarily to prosecute crimes, though intelligence gathered could later be used in criminal proceedings under strict minimization procedures. The judges would review these applications, often in specialized secure rooms, examining the voluminous supporting documents, including affidavits from intelligence officials. They would then issue an order authorizing the surveillance, often with specific conditions, limitations on the scope, and minimization procedures designed to limit the retention and dissemination of information concerning U.S. persons who were not targets. The entire process was designed to be rigorous, detailed, and above all confidential, reflecting the sensitive nature of the information involved. Imagine a scene in the late 1980s within the hushed, windowless confines of a secure room. Special Agent Thompson, a seasoned FBI counterintelligence operative, sits hunched over a thick binder, meticulously reviewing his application for a FISA warrant. His target, a diplomat from a hostile nation, suspected of recruiting American citizens to gather classified information. Thompson has spent months building his case, compiling intelligence reports, informant debriefings, and technical analyses of communication patterns. His legal team from the Department of Justice has scrutinized every word, ensuring it meets the stringent legal requirements. The application details the suspected foreign power, the specific individuals believed to be acting as agents, the proposed methods of electronic surveillance, and the compelling reasons why this information is vital to national security. He understands the gravity of the process. A FISA warrant is not a rubber stamp. While the proceedings are secret, the judges of the FISA are known for their rigorous questioning, demanding clarity and precision in every detail. Thompson mentally rehearses the arguments he would make if called upon, anticipating the judge's potential concerns about privacy minimization for any incidental collection involving U.S. citizens. He knows that his request will be reviewed not by an adversary, but by an impartial arbiter whose sole task is to ensure that the government's need for intelligence does not infringe unnecessarily on constitutional protections. The weight of responsibility is palpable, a stark contrast to the days when such decisions were made behind closed doors within the FBI itself. He closes the binder, a knot of anticipation tightening in his stomach, knowing that the balance between security and liberty rests, in part, on the thoroughness of his work. The initial impact of FISA was generally positive, hailed by many as a vital step forward for civil liberties and government accountability. It brought a measure of legitimacy to foreign intelligence surveillance that had been sorely lacking, transforming an often unregulated activity into one subject to judicial review. For nearly a quarter century, the court operated largely out of the public eye, its decisions shrouded in secrecy, yet its very existence was seen as a crucial check on executive power. However, the world changed dramatically on September 11, 2001. The coordinated terrorist attacks unleashed a new era of national security concerns, leading to a profound re-evaluation of existing intelligence authorities. In the immediate aftermath, the balance carefully crafted by FISA began to shift, as the urgency of preventing future attacks often overshadowed concerns about privacy. The most significant legislative responses were the USA Patriot Act of 2001 and the FISA Amendments Act of 2008. The Patriot Act, passed with unprecedented speed, broadened FISA's scope in several key areas. It introduced the lone wolf provision, allowing surveillance of non-US persons engaged in international terrorism activities who were not affiliated with a foreign power, a departure from the original agent of a foreign power requirement. Perhaps more controversially, Section 215 of the Patriot Act allowed the FBI to obtain any tangible things, including business records, library records, and medical records, if relevant to an international terrorism or foreign intelligence investigation, under a lower standard than traditional probable cause. The FISA Amendments Act, FAA of 2008, further expanded the government's surveillance capabilities, particularly with Section 702. This section authorized the National Security Agency, NSA, to conduct surveillance targeted at non-US persons located outside the United States for foreign intelligence purposes, even if that surveillance incidentally collects the communications of U.S. persons. This effectively legalized aspects of the NSA's warrantless surveillance program that had been secretly initiated after 2001 and later exposed. These legislative changes ignited renewed controversy. Critics argued that the original intent of FISA to protect Americans from unwarranted domestic surveillance was being eroded, transforming the FISC from a guardian of liberty into a rubber stamp for government requests. The shift in focus from targeting foreign powers to combating terrorism, often involving U.S. citizens caught in the dragnet, raised serious questions about the ongoing viability of privacy protections. This evolution sparked a vigorous, ongoing debate that continues to this day. One perspective, often articulated by intelligence officials and national security proponents, argues that FISA, particularly in its amended forms, remains an indispensable tool for protecting the nation from sophisticated terrorist plots and hostile foreign intelligence operations. They contend that the unique nature of foreign intelligence gathering requires flexibility and secrecy, and that the FISC, despite its confidential nature, provides a vital, independent judicial review that prevents a return to the pre-FISA abuses. They point to the court's occasional rejections or modifications of government requests as evidence of its gatekeeping function. Without these authorities, they argue, the intelligence community would be severely hampered in its ability to connect the dots and thwart attacks. Conversely, civil liberties advocates and privacy groups express deep skepticism, asserting that the court, operating in secrecy and without adversarial representation, cannot adequately safeguard Fourth Amendment rights. They highlight the exceptionally high approval rate of FISA warrant applications, which, for many years, approached 100%, as evidence that the court functions more as a legitimizing body than a true check on executive power. They argue that the incidental collection of U.S. persons' data under Section 702 and the broad interpretation of relevance under Section 215 have created a vast surveillance apparatus that potentially sweeps in the communications of millions of innocent Americans. The lack of transparency surrounding the court's opinions and rulings further exacerbates these concerns, making it difficult for the public and even Congress to fully understand the scope and implications of these authorities.